Hello everyone. If you are an investor, insolvency professional, or just curious about how business survive liquidation, stick around till the end. Let's dive in. Sale as a going concern under IBC, whether it is a game changer or risky move. Can a company in liquidation continue to operate like before? Can buyer acquire it without worrying about past liabilities? The answer lies in a unique provision under India's Insolvency Bankruptcy Code IBC, the sale as a going concern. In this video, we'll break down what is a going concern sale under IBC, why it is gaining popularity in corporate liquidation, what are the pros and cons, hidden liabilities, and legal challenges. And we also discuss recent case laws and honorable NCLT judgments. What is a sale as a going concern? The answer is when a company goes into liquidation, its assets are usually sold separately, piece by piece. But what if the business could be sold as a whole, allowing it to continue operating? Sale as a going concern means selling the business intact, including all assets, contracts and licenses, and employees and brand value. So going concern means selling the business as intact, including assets, contracts and license, and employees and brand value. Imagine a textile company facing a liquidation. Instead of selling its machinery separate, land separate, and brand separate, a bidder buys the company as a whole. Then employee keep their jobs, operations continue, and business value also preserved. So why is going concern sale important? The answer is the IBC aims to maximize value for creditors while keeping business alive. That is why a going concern sale is a game changer. It preserves business value and retains the jobs and better recovery for creditors, encourages strategic investors. How it preserves the business value? It avoids losses of brand reputation and operational disruption, and also retains jobs. Employees continue working under the new management. Better recovery for creditors. Instead of selling assets separately, creditors get more value if sell as a intact. Encourage strategic investors. Buyers can acquire fully functional business, not just assets. So now, how does the legal framework support this approach? So let's find out. The legal framework of going concern sale. The concept of going concern sale was introduced under Regulation 32E of IBBI Liquidation Regulations 2016. This amendment allowed liquidators to sell an entire entity instead of dismantling it. So Regulation 32 of IBBI Liquidation Regulations 2016. Regulation 32E allows sale of corporate data as a going concern. Section 54 of IBC liquidation process leading to dissolution if sale fails. NCLT orders going concern sale will be second chance for struggling business. So, but is it always a clear slate for buyers? Let's look at a major legal controversy. See, hidden liabilities is a major challenge. This is very important. See, one of the biggest concern with the going concern sale is hidden liabilities. Do buyers inherit past debts, pending litigations, and regulatory issues? We'll see the case laws. Vishist Services Limited versus SV Ramani. The NCLAT rule that buying a company as a going concern also includes its liabilities. This is honorable NCLAT judgment. So this caused a fear among the bidders. Nobody wants to inherit unknown financial burdens. Latter case, like Decon Enterprises 2022, extended the clean slate principle, providing a relief. So, does going concern sale really clear past liabilities is a question? Not always. That is why bidders must seek specific reliefs from Honorable NCLT. Let's See more strategies. How to reduce risk in a going concern sale. How can buyers protect themselves from past liabilities? First, negotiate for clean slate reliefs in Honorable NCLT. Request immunity from past tax dues, employees' claims, and litigations. Conduct thorough due diligence. Identify contingent liabilities before bidding. Seek regulatory clearance. That is better. Get regulatory clearances. Ensure compliances with tax, labor, and corporate laws. Plan for post acquisition integration, managing employees, managing vendors, and contracts effectively. Now, let's see how going concern sales compare to traditional liquidation. We'll see the difference going concern sale versus traditional liquidation. So, business aspect, continuity. Going concern sale, yes. Traditional liquidation, no. Employee retention in going concern sale, yes. Traditional liquidation, no. What about value maximization? In going concern sale, value maximization would be higher. In traditional liquidation, value maximization would be lower. So, what are the legal challenges? Hidden challenges are there in going concern sale. Lesser in traditional liquidation. Time taken, yes, going concern will take time. Whereas in liquidation, it is a faster. Clearly, a going concern sale is a beneficial, but it requires careful planning and due diligence. Case studies, real world data. Did you know out of 2,547 liquidation cases, only 55 are closed through going concern sale as of 2024 June. So there is just 8% of all liquidated entities. There's a real life example, SKP Steel Industries Private Limited 2023. The Honorable NCLT Calcutta bench allowed a clean slate sale, protecting buyers from past liabilities. This is ruling set a strong precedent. So, what is the future of going concern sale? Let's conclude. Final thought: going concern sales preserve businesses, jobs, and creditors' recoveries because value maximization and hidden liabilities remain a concern. NCLT reliefs are crucial. Legal clarity is improving, but due diligence is a key for buyers. More companies are opting for this method, but it is still underutilized. What do you think? Should IBC make going concern sale even easier? Let me know in the comments. If you found this video helpful, don't forget to like, share, and subscribe for more insights on corporate law and insolvency. Thank you.